Now, Misty is saying, she gave me some other cases to say, no, I have to read the cases where it says all witnesses. Well, I'm going to preface this by saying, even if the case does say that, that shows that you're in a rigged game when the witness who is making determinations against you is not permitted to even testify to that. That it's not, and it's further evidence that it's not a rebuttable presumption, it's an irrefutable presumption. And my whole point of doing all this is to show how unfair the system is. So I'm going to go through this. So the first case that she gives, this, oh, good Lord, what the name of that? I don't want to lose, down on page 5. It's the Simmons Construction Company case, and they're talking about expert witnesses. They're not talking about police officers testifying as experts. They're talking, again, they're talking about experts, and they're not calling the police officer as an expert witness. So, no kidding. I'm saying that the cop is testifying as a regular garden variety witness and that the one who started all of this. So, in order to be considered reliable, proposed expert testimony must be supported on good grounds. Ultimately, the reliability inquiry must be tied to the particular facts of the case, because they're giving opinions. The police officer is not there to testify to just opinions. He's there to testify to facts and the opinions that he made. I think this is absolutely so disingenuous of anyone to say that the police officer can make statements about you and they don't have to testify about those statements. Do you understand about competency and credibility to any degree? Anyone who understands what the purpose of a cross-examination is, which the Supreme Court says is the sine qua non of a trial, it is the be-all, end-all of a trial. It's where you're actually finally testing the prosecutor's evidence and claims. So what they're saying here is that equally important to the gatekeeping function is a determination of whether the proposed testimony is relevant. Thus, even if an expert's testimony is deemed reliable under Rule 702, it must be excluded if it is not likely to assist the trier of fact to understand the evidence to determine a fact in issue. See, they are just giving opinions based on the facts that are already presented. This has nothing to do with the police officer who wrote the ticket. The suggested testimony must fit the issue in which the expert is testifying and should help the trier of fact decide the case. So the Seventh Circuit has consistently held that an expert who supplies nothing but a bottom line supplies nothing of value to the judicial process. Rather, the expert must explain how the experience leads to the conclusion reached, why the experience is a sufficient basis for the opinion, and how that experience is reliably applied to the facts. They're not saying that the police officer, it doesn't even mention police officers. There's nothing, it is not a criminal proceeding. There's nothing in here that states a police officer may not testify to the opinions and claims that he made at the trial, at pretrial, or at the traffic stop. So this is, and I'll include this garbage, well, this irrelevant stuff, because she also cited Spreck v. Jensen, 853 Federal 2nd 85, 10th Circuit 1988. And the holding was that experts' opinion testimony, which amounted to legal conclusions touching upon nearly every element of the plaintiff's burden of proof under Section 1983, was improper. The police officer is not testifying as an expert. All these things are doing about expert. And okay, so United States versus Bilzerian, 926 Federal 2nd, page 285. 1990. Error is also claimed in several evidentiary rulings made at trial, including district court's decision to admit expert testimony by a government witness on the legal requirements of the federal security laws, while excluding similar expert This is about expert testimony. The police officer or the IRS agent who's making claims that is filing an affidavit against you or a traffic ticket is not called to testify as an expert witness. Even if they turn around and they say that witnesses can't testify to the applicability of the code, that doesn't mean that you are not able to cross-examine them. You are able to cross-examine them on the statements that they're making. If it really is that they are not permitted to testify to that, then you know what? Fairness and due process require that they can't make those statements. They may not be able to, if they cannot testify and support their finding of probable cause, then they shouldn't be making it. All this does, if it even applies at all, because it's all expert testimony, and that's not what we're talking about here. Even if it did, it's just showing Misty and everybody else who believes this Galt character. It just means that what they're doing is grossly unfair. No one can tell me any rational justification why a police officer can make legal claims against you, especially if they lead to the raiding of your home. That the IRS can file affidavits against you, making legal determinations throughout the entire thing, which have no business being in an affidavit, which is a statement of fact. And yet they can go in and they can put in these affidavits statements that are legal determinations, legal conclusions, or legal claims. And to turn around and say, well, they're not allowed to testify to that stuff. That is unfair. Because this isn't a matter of they're not testifying. Look, they're making legal claims against you. There's no ifs, ands, or buts about it. If you doubt that, then there's nothing I can do to help you. If you want to equivocate and say, well, they're not making legal determinations, that's just for court. They're making legal opinions, legal claims. They're saying the laws apply to you. And then they say, well, but they're not allowed to testify to that. You can't cross-examine them on that. You're making the case for me about how unfair the whole thing is. That's the whole point of doing this. We're bringing out contradictions and showing how unfair they are. Get it? Well, you can't cross-examine the cop on those statements. Denial of cross-examination would be a constitutional error of the first magnitude, and no amount of showing of prejudice would cure it. And I'm not cherry-picking that. It doesn't just apply to Brookhart. It's a procedural rule. It's a due process requirement. Well, that only applied. Marc's cherry-picking. No, I'm not. Denial of cross-examination is one of the single worst errors a judge can commit. It is the very definition of an unfair trial. And if the prosecutor is able to make claims against you with no evidence, and his witnesses are protected by these stupid court rulings, which they're not, then it just is more evidence, more documentation to prove everything that I've been saying, which is these proceedings are grossly and irrevocably unfair. There is no way to redeem them. You can spin things, you can say these things, you can take court cases out of context, you can say that I'm an idiot. But it's unfair to have the prosecutor rely on a witness you cannot testify, you cannot cross-examine. That's it. Give me 1,000 cases that say this. That even if it says the cops direct, all it does is prove that you cannot cross-examine the witnesses against you, and that is the definition of an unfair trial. That is unfair. Even a due process violation. But I'll finish this in the next segment and try to fix the feed. Misty is desperately trying to do, and look, I'm assuming she's just taking all this and copying and pasting it from Galt. And for those who are tuning into this last segment live, this is a big problem using court cases, and I don't like to use them unless I have to make a point that they're being unfair. And here, what she's trying to do, because Galt came out and said, like, why am I still talking about this guy? But for those who are new, who may be swayed by the gobbledygook that he's putting out there, this legalistic gibberish, police officers or tax agents, when governments attack you and the agent who files the complaint against you, when they're called as a witness, they are not being called under the rules for a expert witness. They're there because experts are they're not presenting facts. They don't have personal first-hand knowledge of the matters they're testifying to. They're giving their expert opinion on what the facts mean and what the facts that are already presented, what those mean. So they're trying to use these cases as support, saying, you know, that expert witnesses can't testify to the applicability of a statute to somebody. Yeah, because they're only testifying based on the facts, and they're not permitted to do that. That's not what's going on here. Gosh, this is so damn dishonest. Again, I am all for dissent, but to send these cases and to post publicly that that's what they said, that's this case, this first one, didn't even use the word cop in it. Cops are not permitted to testify to the applicability. Why? Because expert witnesses aren't? Look, for those of us who are being attacked and going in, our main objective, of course, through damage control, is to show that what these people are doing is unfair from the moment that you're pulled over to the moment you're convicted and the appeal is sent back. Okay, it is unfair. Why is it unfair? Because they like any anarchist would agree, these people who call themselves government are just a criminal organization. They force strangers to give them money. Okay, they're criminals. And so every aspect of what they're doing is unfair. But they put up a front. We are the government. We are here to protect your life, liberty, and property. It says so right here in the Declaration of Independence. It says so in our state constitutions. We have one single goal. One is to protect life, liberty, and property. Life, liberty, and the pursuit of happiness. But that contradicts. You see, the means contradicts with the end. And that's as long as I've been doing this, that is the purpose of why we're doing it. When you get a traffic ticket, when you get one of these tickets, what we're trying to do, what I'm helping you through the process of doing, is to show that what they're doing is contradictory to their public relations, that they're fair, impartial, independent decision makers, okay, as far as the judge is concerned. And we're bringing out that that's not the way it is. We know the judge isn't a fair, impartial, independent decision maker because he's representing a party. That is a serious conflict of interest. And we ask questions to bring that out. We don't say, hey, there's a conflict of interest. We ask questions. Hey, could I get a fair trial if there's a conflict of interest? No, sir, you cannot. Okay. Oh, well, who do you represent in these proceedings, Mr. Mr. Lawyer? They don't want to answer. Why? Because it contradicts their public relations. And so here, it's the same thing. Why are we asking these questions on cross-examination? Because the police officer is making these determinations against us. And he doesn't have any actual evidence to support it. Due process at a bare minimum requires two things, really. Notice, opportunity to defend. And Misty and the one that she's parroting are telling you in plain English, if you pay attention, you don't have an opportunity to defend. That's what you're saying. So thank you for making the case for me, even though the cases don't say that. If you do not have the opportunity to defend against the claim, and it is irrefutably true, and the cop, even if you do ask him the questions, his lawyer will declare him incompetent. They take that testimony anyway. That is the very definition of unfair. So Misty and what, you guys give me 1,000 cases that say, even if they say what you think they say, because they don't. You're just making the case so that everyone listening knows when you get a ticket, it will not be fair. And it's up to us, it's up to you to defend against that by making timely objections, never interrupting that scumbag with the robe on. Let that lawyer who couldn't get a job that the market wanted to pay on a voluntary basis, let him try to argue his way out. Let him try to come up with something to cover for the prosecution. Let him try to make it look fair. Unfortunately, not all of them are interested in doing that. That's a really, we know that Dick Noble up in the Big D, you know, and some judges, they want to threaten you with contempt or a psychological evaluation because you have the audacity to challenge them. And I say, go ahead, do it. At every turn, object and call them out on this BS. We have to show that this is unfair. I've said it for all these years. Our job when we go in, even on a parking ticket, is to make it so difficult for that scumbag with the robe on to make it look good and fair that they throw it out. Oh, this is too much trouble. You're damn right it's too much trouble. Of course, you're trying to justify gross immorality that anybody with half a brain in their head can see the judge is acting on behalf of the prosecutor. Oh, but they're from a different department, Mark. Yeah, like I said before, football teams have an offensive line, they got a defensive line. They got the same objective, don't they? Learn a little bit about human sociology and psychology before you make such stupid comments that just because someone is from a different department in the company, that they're not part of the company. None of this, none of it. It's all about expert witnesses. Expert witnesses. So, not applicable. Again, if anyone tells you that someone can make claims against you, and you can't cross-examine them on that, call BS. Object, and you may have to appeal. But imagine the time the lawyers are going to have to try to justify that denial of cross. Well, what they can do in the Fed courts, they just, well, you waived your right to cross-examination. You waived it. They just lie. They just lie. The court finds that Murphy's second opinion on the invades on the province of the court to interpret the requirements of Rule 26. Whether Green complied with Rule 26 is a question of law that is clearly reserved for this court. Similarly, whether plaintiff's counsel's actions were negligent is also an inadmissible legal conclusion which Mr. Murphy may not proffer. However, Murphy's remaining three opinions are relevant to the issue of sole proximate cause, and he is clearly qualified by experience to give them. Further, the court finds that his testimony in that regard will assist the jury in determining the sole proximate cause. Expert. So some of it he was allowed because he's basing it off of his expertise and off the evidence that was already given. He's testifying as an expert, and where he wasn't allowed, when they're saying it's on the province of the court, he wasn't offering testimony. You see, the thing is, this expert testimony wasn't the one who filed the complaint. He didn't make those statements prior to the trial. Do you see how this is apples and oranges here? Expert witness may not do that because they're not statements that made prior to the trial that started the whole thing. When you get a traffic ticket, the cop is making these legal determinations. He's making these legal opinions. Cross-examination, competency, credibility, everything he said and did prior that's relevant, subject to cross-examination. Yeah, my name is Marc Stevens. It's been live from the Fortified Compound, May 5th, 2018. I will be live on the Wednesday broadcast. So we'll be back. So till then, salute.